I changed the title of the program on wills, trusts, and estate plans, or estate planning, putting it all together. I had used the same title all through COVID when we went virtual. And I was talking to my mom, who was a quilter, my mother-in-law, who was a quilter, and my sister-in-law, who was a quilter. And I used to be a quilter as well in my past life. And I realized that as we were talking, the process of putting together an estate plan for a consumer requires almost putting together the pieces, like you take pieces to make a patchwork quilt to create a full blanket. We do the same thing in a way as lawyers, where we're listening to put together what plan will work for you. And so this program is going to talk about some words that you hear to prepare you for estate planning. So the first thing that we usually deal with as lawyers is, people who delay. And I deal with, as many estate and elder law attorneys do, we deal with a lot with crisis. So planning, why do people delay planning? Well, superstition is very common. I still have a client that I think of all the time. If I plan, it's going to happen to me. If she signed a will, she was definitely going to die, even though we all face death. If she signed a healthcare proxy, which we'll talk about, she was definitely going to get sick. The other reason that people delay in planning is that stories from their past, their experiences from the past. So I often hear, well, when my mom or my dad or my grandma passed away 25 or 30 years ago, we only had to walk into the bank and they gave us the money, they let us take things out. Doesn't work like that anymore. Banks have consolidated, rules are stricter, and so there's a way to deal with that. And then frightening advertising also has sometimes the opposite effect of getting people to plan. It scares them. And so, even I get flyers at my home. Make sure your assets go to the people you love. Don't let the government take away your assets. The IRS isn't interested in your assets unless, as we'll talk about, you actually owe inheritance taxes. And of course, my favorite is you must have a trust to avoid probate. And the implication is that you're going to save estate taxes, and that's not necessarily so. There are reasons, as we'll talk about, to avoid having a will go through probate. So you can see that there's a lot of reasons to delay. So we're going to tackle some of the words to get you energized and moving forward in 2023. So what is an estate plan? When you say, when I say to you, what's an estate plan? So you can see an estate plan means passing your assets after your death to persons or charities you want to benefit. And you can do that with a will, which is a written document, or you can do it with living trusts, which we'll talk about, or even with testamentary, or what we call inherited trusts, for people that you love or care about. An estate plan also looks at managing healthcare decisions if you become incapacitated or have some level of diminished capacity, whether due to dementia or some other cognition issue. And so we'll talk about a healthcare proxy and a living will. And then what happens as part of the estate plan with respect to managing your finances if you become incapacitated or develop diminished capacity. And so we'll talk about a power of attorney, and we'll also talk about a living trust. So those are the words that you hear. So wills, or a last will and testament. So what is a will? So it's a written document, and in New York State, it must be prepared by a lawyer. The online programs, I think it's called like Zoom Legal or something, those are actually not legal in New York State. And the lawyer who prepares your will has to be admitted to practice law in the state where you reside. I had a case I was involved in. I actually represented the court about 20 years ago. And aside from the contesting individuals over the terms of the will, what came out in the course of the litigation was that the lawyer who prepared the will and witnessed the signing was actually a disbarred lawyer. In other words, someone who was not admitted to practice law in the state. So wills can be simple and provide for your family or loved ones. If you have children who are under the age of 18, the will can appoint a guardian for the minor child or children. And the will can pass assets or income, if it's a business stream of income, to designated persons or even to charities. Wills can be more complex or sophisticated. So if you require inheritance tax planning, it can provide for estate tax planning for a married couple if your assets in total will exceed the federal or New York State inheritance tax limits. And I'll go over that a little bit later in the program. A will can create a trust for a beneficiary to manage the money while they're a minor. For example, up to the age of 18, which is the age of majority in New York State, or longer. The will can provide for a person who has disabilities, and we'll talk about that. It can provide for a trust for someone who's simply not good with money. And it even can create charitable trusts. So what is a simple will? So there's no real definition, but most lawyers refer to a simple will when the will simply says that you're leaving your assets to your immediate family, such as a spouse or children, and it, of course, can include charities and even more distant relatives. The will directs who will manage the estate, and this is called the executor. And if your will has a trust in it, an inherited trust, the will directs who will manage this trust, and that's called a trustee. Now, as I said before, for children under 18, you can designate guardians for the hopefully unlikely event of what happens if the parents pass away. For children over age 18 who have a developmental disability or are otherwise incapacitated, you cannot name a guardian in your will that lasts beyond age 18. And that's a separate legal proceeding to appoint a guardian, sometimes called a 17A proceeding in surrogate's court, and sometimes called an Article 81 guardianship proceeding in Supreme Court. So minors under 18, absolutely, we always appoint guardians in wills for minors, but at the age of 18, that guardianship ends. Can wills handle estate tax planning? And of course, the answer is yes. So for a married couple owning more than the New York State or federal tax limits, wills can have tax clauses which do that estate tax planning. And those are sometimes called bypass trusts or credit shelter trusts. So the trust shelters a certain amount of assets left to a surviving spouse, and on the second to die, the assets that were held in the bypass trust bypass inheritance tax and, in theory, pass to the children without any taxation. So you can see in 2023, New York State increased the threshold for inheritance tax to $6.58 million per person. So for a couple, that's double that, over 12 million, almost 13. That should say 2023, that's a typo. In 2023, the federal threshold for taxes is over 12 million. So for a couple, it's 24 million. So to put that in perspective, if a couple owns at their death together on the second to die, $5 million, they wouldn't have had to have, I'll say, worried about estate tax planning. If they were bumping up together at the double the New York State amount, approximately 13 million, then they probably would be advised to create in their wills a bypass trust or credit shelter trust provision. Now, for a single individual, the tax planning in the will, other than what you can pass without taxation, as I said, for example, the New York State amount allows a single individual to pass over $6 million. Most of the other tax planning might be, for example, through giving money to charities where you don't pay inheritance tax. Now, there are other sophisticated methods that can be done in wills that we're not going to discuss in this program, but know that if you have an issue or concern about inheritance taxation, then by discussing it with the lawyer has tools in their toolbox to do this through a will, to do the estate tax planning. Now, we have a really interesting provision in federal law that, let's just say that a couple are bumping up against the federal inheritance tax amount, right? So the 12 million, so they would have done a tax planning will to cover the issue of paying and avoiding paying inheritance tax on the second to die to New York State, but they still need to protect against federal inheritance tax. And so a lot of times what we see is that the surviving spouse files a no payment tax, no estate tax return. And in the federal government, they have something called portability. So if the first spouse who dies had about 3 million that they passed without tax, and the other spouse is left with now 9 million of her own assets, if the first spouse to die didn't use that full 12 million, that surviving spouse picks up the leftover amount. Now, in the federal estate tax world, the credit, that over 12 million per person, is scheduled to end in 2026. And if it does, we believe that it's going to revert to an amount that's close to about half of that, to the New York State amounts. So a lot of lawyers look at the numbers, look forward with the clients, and a lot of times suggest an estate tax planning will, just in case. And as a reminder, in New York State, we have no what's called gift tax. And a lot of people are familiar with, can I give a certain amount per year to my grandkids, to my kids, to whomever? And that's called the annual exclusion gift. And you can give in 2023, $17,000 per person. So if you have 5 grandchildren, they would be very happy to get $17,000 each per year. And you wouldn't have to file a gift tax return, and there would be no gift tax. Okay, so continuing the discussion of trusts under wills. So we talked about a tax planning trust. As I said, we call them testamentary trusts. So testamentary trusts under a will also capture an inheritance for purposes of managing it according to how you want it managed, even though you're now passed away. So again, using minors as an example, children under 18 should never inherit assets directly. I question whether children between the ages of 18 and 25 should inherit. Some of my clients question whether their children should ever manage their funds directly, but it's your choice. But certainly while they're under the age of 18, the court, if there's no trust for the minor, the court will require that the parent, surviving parent, or other relative who's now the guardian become the guardian for property management. And then the money gets deposited into the bank selected by the court, and it basically is very difficult to use. Now, if you have an inherited trust under the will, then the money can be used for the minor's support, for their education, and typically at the end of the trust, it's distributed in full, depending upon the ages that you've picked. Now, if you have more than one child, the will can direct that the funds be divided up into like separate bowls, like little separate trusts for each of your children. And that's a good thing because your children may have different needs at different times. In addition, I think it was in 2021 or 2022, we had a significant change to how IRAs, those types of retirement accounts are managed. And so typically if we're leaving IRAs in a trust to our children, such as a minor's trust or a children's trust, you need to have separate trusts set up within the will so that they get the benefit of the IRA under the law. Now, for disabled children, including disabled adult children or disabled grandchildren or nieces or nephews who may need public programs such as Social Security Disability, SSI, or Medicaid, in New York, and in most states, but in New York, we can create within the will an inherited special needs trust. And sometimes it's called an inherited SNT, and we have a unique way of calling it an Escher trust, as you can see in the slide. And that's because the law is named after, and the trust is named after a case that was decided in New York State and really set the tone for the nation. So in terms of the trust, you would be describing to the lawyer, what your child's needs may be or could be, and then the trust could be designed to meet those needs within the boundaries of the law. And this is when I talked about before the fact that you might have a trust for minor children. You can have, if you have minor children or a trust that you're planning to do for children that maybe goes to age 25, and if one of your children is under a disability, you definitely want to have a separate special needs trust. And that's because when they changed the IRA rules under the Secure Act, they kept rules that benefit persons under a disability who had an onset before age 26. It allows them to have the IRA paid out over their lifetime instead of over a 10-year period. So all good things with an inherited trust under a will. So the special needs trust that's inherited springs to life when the parents are deceased, right? So that's when, if you think of a trust as a bowl. Now, sometimes the trust is funded from outside the will and it flows into the trust. And a good example of that is life insurance. So the parents or family member may do a will that says, I leave everything to my son in a special needs trust. And then they go to their insurance agent and they change the beneficiary so that the beneficiary is, for example, if they have 3 children, 1/3 to the trust under my will for the benefit of my son, blah, 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 which is a special needs trust. Excuse me. We do that with IRAs as well. So the discussion of how to fund the trust must be done with a lawyer so that the disabled person doesn't accidentally inherit the money or the property outright. And once it's in effect, the trust is used for the sole benefit of the disabled person during their lifetime, and when used properly, does not affect their eligibility for Medicaid, SSI, or other benefits. Just like in a minor's trust, the trust is used for the sole benefit of the minor. And the other interesting part of an inherited special needs trust is that it doesn't stop when the adult heir, the trust beneficiary, turns age 65. It can go for their lifetime. Now, the other interesting thing in New York State is if I have a sister who's disabled in any manner, or I have an older sister who might become disabled as she ages, I can also do an inherited Escher, inherited special needs trust for her benefit. And if she ended up on public benefits or in a nursing home, the government could not take that money either. So there's a wide variety of uses for special needs trusts. I mentioned before that sometimes we do special needs trust, we do inherited trust for family members. So client comes to a lawyer's office and they start to tell a story about how their adult child is just not good with money, or their adult child is now married and they've moved to a community property state like California and Arizona. And it's not like New York, where inherited property is not necessarily marital property in a divorce. Or maybe the heir has married someone who has issues with drugs or other substance abuse, or the spouse suffers from mental health. Or, as my mother-in-law uses the term outlaw, Maybe they just don't like their new in-law, right? They just don't like them. And what they're concerned about is if their son, their daughter dies, that their in-law would now have the money for their second spouse. So all of these emotions and all of these facts go into the idea that a lawyer can create a trust, an inherited trust under the will. We don't have to call it anything. It just becomes an inherited trust, and it goes for the beneficiary's lifetime. So what passes through a will, right? You do a will, what's going to go through the will to create the opportunity for these trusts, these bowls, if you will, to be filled. So any type of asset or income can pass through a will. And when it goes through the will, what that means is it's not jointly owned with someone. So if I have a joint bank account and I die, that's not going through my will. That's going to the person who owns it jointly. There is no beneficiary. So if I name a person, a named beneficiary on an account, such as payable on death, or a beneficiary of life insurance or an IRA, that's not going under my will. That's going to the named individual. And so the most important part of your estate plan is not just stopping with preparing and signing the documents. It's making sure you know what you want to pass through your will and to whom. Okay, so we step away from wills and now we move into a living trust. So what is a living trust? So a living trust is a legal document you create while you're alive, and it must be, we're in New York State, it must be prepared by a lawyer. The document can also avoid probate of your will after your death. And that's when a will is offered to the court after your death to collect assets, fund the trust. That's called probate. Now, there are many different types of living trust, but a few basic ones include a revocable living trust, a life insurance trust, an irrevocable Medicaid trust, a special needs trust, and a minors or education trust. So what is a revocable living trust or revocable trust? So it's a document. You can be the creator of the trust. Sometimes we use the word grantor or settlor. You can be the trustee, which is the manager of the trust, and you can be the beneficiary. Now, the assets in a revocable trust are not protected from creditors. And if Medicaid were going to be a creditor, it would not be protected from them. Now, for a married couple who need estate tax planning, but don't want to have probate, don't want to do it through a will, they can each prepare a revocable trust, and they can have the same estate tax shelter provisions, the bypass trust, for inheritance tax planning as in a will. It's identical. So it's not the fact of a trust that does it. It's the fact that the lawyer writes into the trust the required tax clauses, the bypass trust tax clauses, which allow the estate of the individual to pass with minimal or no inheritance tax. So again, just preparing a revocable trust for spouses without the estate tax bypass clauses or provisions doesn't minimize or prevent estate taxes. That's where the false advertising comes in. Now, if you become incapacitated and you can't manage the trust as trustee, the trust usually designates a successor to manage what's in the trust. I have a client who's been my client for about 15 years, and we did a revocable trust after she became widowed 15 years ago. She is still completely with it and competent, but she's homebound for a variety of medical reasons, and she can't manage the trust. So we're in process of having the successor step up. But if you were incompetent, we wouldn't need the trustee, the original trustee's consent. We would do it with medical information, and the lawyer prepares a document so the successor steps up. But it provides for succession planning. So a trust must be funded, right? It must have something in it. So you can place your home in the trust by deed. You can retitle bank accounts or investment accounts in the trust by retitling them. Some people with some types of accounts, not the house, like a financial account or a bank account, what they instead do is they designate their trust as the beneficiary of the account if the bank will allow it. So the bank account will say, my name, payable on death to the Beth Polner Abrahams Revocable Living Trust. So again, that's something that you work out with the lawyer and with the institution. And at your death, the trust acts like a will because it passes the assets in the trust to the persons or charities designated in the trust document, just like an estate after the debts are paid. And the only thing is that there is no probate. No will has to go to the court. Whatever is controlled by the trust is distributed. So if your home is in the trust, then at your death or at the second of the spouses to die, the heirs, if you will, whoever's listed to receive the home, the trustee sells the home, and then the proceeds come into the trust. And then after your debts are paid, if you have any debts, then it's distributed. There's no delay with probate. So another type of living trust is a life insurance trust. And we saw this a lot during the 80s and the 90s and the early 2000s because the amount you could pass to your heirs without taxation in New York State and federally was quite low. So life insurance trusts are a form of an irrevocable trust. And the way it works is that a life insurance policy is purchased, it's owned by the trust, and after a certain period of time, once the trust owns the life insurance, at the death of the individual who is the insured, the proceeds are not subject to estate taxation. So you can be the creator of the trust, but you cannot be the trustee. So if it's spouses, sometimes we have, for example, if the one spouse is going to be the insured on the policy, the other spouse might be the creator of the trust or the trustee of the trust. There are other steps that are required to be taken to make sure the trust remains insulated from inheritance tax, but it is an option for people. Why do people do life insurance trusts? Because even now, people with a certain amount of wealth, and in the old days, I'll say, it provided a tax-free source of funds to pay inheritance tax. There were other reasons they did it, but that was one of the reasons. So only a lawyer can draft this trust and work with you and your insurance professional to title the policy, whether it's new or it's an existing policy, into the trust. And just by way of example, typically this isn't done with term policies because they end. You see it more frequently with what's called second to die life insurance and whole life policies. All right. So again, another tax planning trust. Okay. So the irrevocable Medicaid trust, this is actually a whole other program on elder care, but it is part of trust, so I decided to include it. So again, an irrevocable Medicaid trust is a living trust, and it does everything that a revocable trust does. It avoids probate. It only covers those assets that are actually put in the trust. But what it's known for is that it's the most common strategy for protecting assets before you need Medicaid for services, primarily before nursing home care, but also for home care. So an irrevocable trust, again, which is a written document prepared by a lawyer, you can be the creator of the trust. You are the beneficiary of the trust, but you cannot be the manager. You cannot be the trustee. Now, in most trusts, the trust gives the beneficiary the income, and income has different definitions depending on what you've put into the trust, what you've funded the trust with. So if what you're putting into the trust is a deed to your home or a deed to rental property, it means that if it's your home, the income right means that you can keep the veterans exemption if you're entitled to it, star exemption if you're entitled to it, those reduced real property reductions. If it's rental property, then you keep the rental income, or what we call the net rental income, right? If it's a portfolio that you've put in because maybe you rent and you never bought, or you sold and invested and now you're putting that large portfolio in, the dividends and interest that are generated are yours. That's considered income. Now, when we put a home in to a trust, a well-drafted trust gives you the right to remain in the home until you want it sold. In other words, under certain conditions. So most lawyers will put in that you have a right to reside there. If you consent to the sale, then the trust may say that if the home is sold, a substitute residence can be purchased, and a few other things like that. Now, at your death, the trust acts like a will, just like the revocable trust, and distributes the property to persons listed, again, without probate. A trust that's irrevocable also has specific clauses that a lawyer will use that preserve various income and gift tax exclusions for what's in the trust. So from the perspective of the house, the clause that's put in allows, under current law, the home to receive at the death of the trust owner what's called a step up in basis. So if I own a home that I bought in 1962 for $15,000, and when I die, my home in the irrevocable Medicaid trust is now worth $900,000 because of where it's located. My children, my heirs, receive that home, inherit that home at the date of death value, the $900,000 figure, because the lawyer did a good job with drafting the particular clauses that allow for that to happen. And so they sell the home without any income tax, capital gains tax. Now, it is called an irrevocable Medicaid trust. So for purposes of nursing home care, the trust must be created and funded at least 5 years, 60 months before the need for Medicaid to pay for nursing home care. We don't have this same type of waiting period yet for our Medicaid at-home program. That, though, is expected to begin in March of 2024, unless the current governor decides to undo what the prior governor did. And so, again, right now, what we're living with is still the 5-year, what we call look back or wait period, when you place a home into a trust or otherwise give away assets. Okay, so that's the Medicaid irrevocable living trust. Now, I talked a lot about the special needs trust, the inherited special needs trust, but I just wanted to mention that there's also something called the living special needs trust. Now, there's 2 types. The first type is when someone creates a special needs trust with their own property or funds. In other words, they're making a gift from themselves to the trust. And this is called what's called a third-party special needs trust. In other words, the money didn't start with the person under a disability. Now, to do the special needs trust, it's a living special needs trust, the beneficiary, this type, the beneficiary must be someone with a disability. A disability doesn't just mean that they're receiving some form of disability income. They can have a history of a disability or impairment. and you would be creating the trust. You can be the trustee. You can select someone to serve as a trustee for the benefit of the disabled person, either during your lifetime or after your death. And the trust continues after your death for the benefit of the disabled person. And why a lot of people do a living special needs trust or this third-party special needs trust instead of putting it in their will is because there's aunts and uncles and grandparents and cousins who say, hey, I want to leave money to, this individual, and I don't want to pay a lawyer for a special needs trust in my will. So, for example, I might set up a living special needs trust for the benefit of someone in my family, and I tell them all, and they bring the words to their lawyer, and all the lawyer has to do is say, I leave so-and-so's child this amount of money within the special needs trust for the benefit of so-and-so, dated January 2023. So they're not paying their lawyer for a full inherited special needs trust. They're paying their lawyer for a will with an extra line. So the most important thing about what's called this third-party special needs trust, because the money did not start with the disabled person, is when the disabled person passes away, anything that's left in the trust gets distributed according to the terms of the trust. Maybe it's a charity, maybe it's other family members. It does not get paid back to the Medicaid program. And that's because you used your own funds to create and fund the trust. So sometimes we talked about, what goes in a Medicaid trust, but what else is just to refresh, can fund any sort of revocable or irrevocable trust, or even a special needs trust, a living special needs trust. So your home, a condo, rental property, vacation home, investment accounts, we talked about stock, a stream of income. Sometimes we have a business entity and what they're entitled to is a stream of income. Out-of-state property, vacant land. A lot of times we see the use of revocable living trusts because individuals own their home on Long Island, they own a home up in Massachusetts, maybe they have another place in Florida, and instead of having a will where their heirs have to go probate here, probate there, probate in the third state, they create the revocable living trust and all the properties go in there. One cautionary note that sometimes cooperatives generally decline or refuse to transfer shares to, mostly it's irrevocable trusts. So then you might have to consider other options with the lawyer. And depending upon the type of the living trust, sometimes an accountant should be involved in determining, the income tax consequences of a particular asset or stream of income being used to fund the trust. So sometimes a client comes into a lawyer, we use the term simple will, and the lawyer should say, let's talk about your assets. Maybe there's other ways to pass your assets at your death. Now, it's always a good idea to have a will, a simple will, but sometimes we can get rid of the bulk of our estates without having to worry about probating the will. And that usually happens, once we know the lay of the land, who we want to inherit, no one's under a disability, that sort of thing. So for financial accounts, you may designate a beneficiary to pass the account without the will or a trust. And most banks refer to that as payable on death, or POD. The old term was ITF, in trust for. I recently came across a bank that said, oh, we still use that term. I'm like, really? Okay, whatever it takes, just give me the form so I can complete it with my client. Investment accounts use the term transfer on death, TOD. And life insurance, annuities, IRAs, 401ks, those sorts of accounts, those can all have beneficiaries. You get the beneficiary designation form from the institution. You list a primary beneficiary, and you can list a contingent beneficiary, right? Now, that won't work if you have a special needs trust, right? Because you don't want the individual to get it outright, and that's where the lawyer can help with designating the beneficiary or the contingent beneficiary. It also won't work if you're doing a trust for minor children or up to a certain age. So just cautionary note. Joint banking account. Making accounts joint means that the joint owner inherits. It passes, your assets automatically to the joint owner. And so again, the cautionary note is if, for example, you have 3 children and only one person is joint, you need to have a conversation about what your intention is. Is your intention really to benefit that one child, or is your intention to have that child use the money to pay the debts of your estate, maybe the carrying charges on a house until it's sold, and then divvy up the balance? And then the last one that is used is something called a life estate deed. So we talked about a trust, whether it's revocable or primarily irrevocable for Medicaid purposes, right? The house is transferred in by deed into an irrevocable living trust. Well, sometimes people don't want an irrevocable trust. It's too hard for them, it's too expensive for them. So another option is where an individual who owns the house or a couple transfer the home to, for example, their children, however many they have. And they retain the right within the deed description, what's called a life estate. So you'll see in those deeds, it'll say, Beth Polner Abrahams retains a life estate in this property for the entirety of her life, right? And that's called a life estate deed. Now, a life estate deed does accomplish the idea of passing that property at your death without probate, without the necessity of a will being offered for probate. It also does Medicaid planning. It's considered a gift. So if you transfer the home to your kids or whomever and retain a life estate, you have to wait 5 years. You have to stay out of a nursing home for 5 years before Medicaid will pay for your care, right? It's the same as the irrevocable trust. And the other good part, just like an irrevocable trust, is the life estate means that the individual who gave the house away was keeping just a little bit. So when they die, the individuals who receive the home, for example, their children, they inherit the home not at what I paid for it in the 60s, for example, $15,000. They inherited at that stepped up date of death value under current law. Now, the drawback to a life estate is it really does presume that the lawyer has had a conversation with you about where do you want to live? Where do you want to stay, right? So I have a commitment to my mom. She's never leaving her home, and we've taken steps to make sure she's safe, right? But if someone can't make that commitment, if someone says, well, gee, I don't know, I always wanted to see South Carolina or something of that nature. When a home is sold in a life estate, the senior gets a small portion of the sale proceeds based upon their age, and there's a chart, and the kids or whoever received the home get the rest. The kids pay income tax, capital gains tax on that. The senior does not. If the senior is in a nursing home and the house is sold, that money would likely go to Medicaid. When a house is in an irrevocable Medicaid trust and it's sold, the money stays within the trust and then can purchase another place for the senior. So again, life estate deed is a really nice way to protect an asset, pass it at your death. Just requires a lot of considerations. Okay, so in just the last few minutes, and then we'll go to questions, I wanted to just talk about managing healthcare decisions if you become incapacitated. And so the document that doesn't need a lawyer, it's called a healthcare proxy, right? And this one-page document is for healthcare decisions when you can't tell a doctor your medical treatment choices. It covers all medical decisions once a doctor, a nurse, a social worker, a medical professional determine you lack medical competence. And it's not just for end of life. So if someone is elderly and has diminished abilities due to, for example, dementia, they can't remember the moment a doctor tells them what their diagnosis is or their treatment options are, or wants to have a discussion about what medication they're on, that doctor can certify that you, as the healthcare agent, can now be in the room. You can be part of the conversation. You don't have to worry about confidentiality, that sort of thing. And you don't need a lawyer to prepare the healthcare proxy. You can get the document. You can type into any search engine, New York State Department of Health healthcare proxy, and the form and instructions come up. The New York State Bar Association has a form. If you're working with a lawyer, the lawyer should be doing it with you. And the document is witnessed by 2 people, and it's not notarized. So it's a very important document. These days, a lot of lawyers, scan the documents and email the healthcare proxy to the client, and the agents keep it on their phone, right, in their wallet, so to speak. Once the document is in effect, the agent can make an array of decisions: surgery, biopsy, anesthesia, medication, routine medical exams, right? All the way, excuse me, to end of life decisions such as feeding tubes, which is New York calls artificial nutrition and hydration, and other end of life decisions. So one of the most important documents you can do is called a power of attorney. So who's going to manage your finances if you become incapacitated? So the power of attorney is a legal document that must be prepared by a lawyer. You cannot do it online. I've seen many mistakes. You can't buy it in a old-fashioned 5 and dime store. It has to be done by a lawyer. So once you are unable to manage your finances, either because you say I can't do it, or a doctor says they can't do it, or you agree that you can't do it and you ask the agent to step in, maybe you're competent, but you're locked in your home for a variety of medical reasons. So they can make financial decisions, pay bills, take care of your assets and property. You can designate more than one person. If you want, typically a married couple might designate each other, and then they name backups. You can name successors, multiple successors. Some powers of attorney, well-drafted ones, have future planning, such as the authority of the agent to create trusts or make gifts for estate tax purposes, or to make gifts or transfers for Medicaid planning. So whether it's estate planning or elder law planning, you should always work with a qualified attorney, qualified elder law attorney, qualified estate planning attorney, if you're going to be making the power of attorney part of your estate plan, excuse me, and you expect to have gifts or transfers, particularly when a will might be different from the gifting authority in a power of attorney. So again, a cautionary note. But it's a very important document to have. What happens if you don't have a power of attorney and you become incapacitated? Then your family has to bring a legal proceeding to appoint a legal guardian, and it's both costly and distressing. So lots of reasons, not to delay, lots of reasons to just go for it and find, qualified legal assistance. As I say in the conclusion, the best plan is to take time for proper estate planning, legal advice and counsel with a qualified estate planning attorney and determine what planning is needed. And fear should never be your motivator. Control of your life, your legal future, and your own decisions should be paramount. So again, my office is located in Garden City. The phone number for the office is 516-741-9175. You can also find me, just type my name in, you'll find my website. And again, if you would like to have before we open this up for questions, a free legal consult that would be specific to you, please feel free to give a call.